Good morning, Mr. Kelly.
Good morning, Your Honor.
Maybe you could get some clarity in a different area of law.
Yes. No expectations of privacy. We're here on behalf of Moses, an organization that represents some 3,000 employees in Unit 9 who work for the Commonwealth and the MWRA. The case involves a discharge of one of the Moses members, Mr. Robert Pino, in April of 2007. The union protested the discharge, filed a grievance, and the matter proceeded to arbitration. There was a question before the arbitrator on whether the case was arbitrable. The arbitrator ruled that there was a just cause provision for discharge in the collective bargaining agreement, and it was arbitrable.
In his decision, essentially saying he was going to go forward and arbitrate it, he doesn't mention anything except for the just cause claim. Would that include the discrimination claim? I mean, you're arguing, I suppose, that he was fired or because he was engaged in union activities.
Well, the grievance includes union activities, as union discrimination is one of the claims, correct?
He doesn't make any mention of that in what he says he will arbitrate. Does that make a difference?
I think no, I don't think it makes a difference. I think the point the arbitrator was making is that we have an arbitrable dispute. The arbitrator
But
found
if it's not,
under the just cause, the colonel in the discharge letter didn't mention union discrimination either, just said, I have just cause to discharge you, and I have the authority to remove you from public service.
Mr. Kelly?
I'm sorry, Your Honor, go ahead.
If your argument is that Mr. Pino is covered by Section 10, is that right, of 22C?
Well, that's one of the arguments, Your Honor, yes. I would say that the reason the arbitrator deferred to the court was to determine whether this claim of non-delegability under Section 9 has any validity. And I would say, yes, I would say the judge was wrong, that this Section 9 doesn't do what he says it does.
Well, if Mr. Pino is covered by Section 9 and not 10.
And not 10.
And not 10.
Yes.
Does that change your position?
No. No.
You still think that this is an arbitrable dispute if he's covered by Section 9?
Absolutely. Absolutely. I mean, this issue of it may be that you could read the statute. I don't think it's a proper reading of Section 9, but you could read the statute as saying the colonel has a right to appoint an expert. Mr. Pino is an expert. Therefore, Mr. Pino is covered by Section 9. I get it. You could do that. I don't think that's a proper reading of the statute, to be honest with you. But even if you did that, that doesn't lead inexorably to this broad, I have the right to fire people for any reason I want.
Well, does it lead to just to follow up on Justice Cordy's question, I think it's a follow-up. You are saying the fact that it's for any reason, not necessarily, I'm going to be careful here, for a reason that is against public policy, union activity, discrimination, something like that, makes no difference. He just can't do it unless there is just cause, and the arbitrator can look to see whether there is just cause in the sense that he looks to see whether there was some failure of performance.
That's correct.
So you are saying, in essence, that there's no category of people who report to the colonel that the colonel can decide to terminate unless they failed in the performance of their job somehow. Is that your position?
I'm not going to go that far, Your Honor. I look at Section 10
right.
as essentially a manning, staffing section. The governor tells the colonel, how many officers and other employees he may hire. That's what Section 10 says. Section 9 says the colonel, all on his own, without the governor's blessing, can hire clerks, experts, and other assistants. I look at that as saying, here's what you got for your department, and if you want to hire temporary people because you need them, then you have the right to do that, colonel. I think that's what Section 9 says, frankly. That's how I read those two sections. Now, do all of those people, let's say we have a case and we need an expert, and we hire them. If we hire them for 30 days, can we remove them after 30 days? I would say absolutely.
Yeah,
Now-
but there you're really talking about hiring an expert on a contract basis.
Correct.
They're an independent contractor.
Correct.
Section 9 seems to contemplate actually hiring them as an employee of the Commonwealth of Massachusetts with retirement benefits, because they talk about appointing, and I think the word's appointing, and removal.
Yes.
It does say appoint and removal. That's
Yeah.
absolutely right.
So they're talking about putting somebody in as in employment status, not as independent contractor status.
I would think that's right, Your Honor, that the status of the person is going to be an employee. I would think that's right. They don't have civil service rights because Section 9 says you don't have them. I suggest they have collective bargaining rights. The collective bargaining agreement,
Why would they have collective bargaining rights? Section 10 specifically refers to Chapter 150E, but Section 9 doesn't refer to it at all. It really seems to make them completely at will.
well, I'm not so sure about that. There are, and if you look at the AFL submitted an amicus brief, there is a laundry list of appoint and removal statutes that are sprinkled through the general laws. There are not quite 100, but close to it, officials who have appoint and removal authority. Now, to say that each one of those appoint and removal authorities, because it isn't linked to 150E, then all of the people who are appointed have no collective bargaining rights, I think is a broad step, Your Honor.
Let me just go back to where the Chief Justice was inquiring about limitations on power. In the Southern Worcester County Regional Vocational District case, which I think you both cite, this court specifically said that the non-delegability doctrine did not apply in circumstances where there was a anti-union discrimination. It's not an exception. It just doesn't apply. Now, at least that's what the case seems to be saying. If there is a limitation on the colonel's, if he does have non-delegable power, and if Chapter 150, Section 10 places a limitation on that power for or against removal of people for union activity, what is the scope of arbitration if somebody is fired? And if we were to say, no, this is at least it's arbitrable, but we're trying to figure out the scope of arbitrability. Does the arbitrator look to see if there in fact was any legitimate reason to fire? Is the inquiry limited to whether or not the termination included anti-union discrimination? What's the scope of the arbitration in that circumstance?
These are not uncommon cases, Your Honor.
But what's the answer? Because Justice Pena just asked more clearly what I was getting at.
The arbitration would proceed on both a just cause and a union discrimination.
What's the basis for proceeding on the just cause basis?
Yeah.
Isn't that?
Yeah. I mean, does the arbitrator just lift up the curtain and take a peek to see if there's a basis for just cause in relation to evidence of anti-union activity?
Well, they're actually
The arbitrator can't override the finding of just cause, can he, or can she?
yes. Oh, absolutely.
Even in these circumstances, you see?
Yes.
I mean, it's like, what's perplexing to me is, if that's the case, then these employees, if they are employees, are no different than any other employee, is your position, correct?
That's right, Your Honor, except they're not in the only difference that I can see is that there's a formalized process for setting the budget, which seems to be Section 10, and you need the governor's blessing to get however many people you get. And then you have a reservoir of authority, the colonel does, to hire supplemental
But
people.
that can't be the case because the colonel's got to get his money from somewhere.
Well, he gets his money from the legislature, no question about it, but he doesn't have the right to hire as many permanent employees as he wants.
But you're
Those are
saying,
Section 10 employees.
but you're saying these are permanent. I mean, what is the difference for those purposes then? But he gets a budget. Let's say they get paid $10,000 a year each. I know they don't. And so he gets a budget for 100, and so he can hire 10 employees. He can't go and hire 11. So what's the difference from a practical point of view between Section 9 and Section 10 if we accept your interpretation of the statute? Namely, I just don't see the difference, because he can't hire people unless the legislature appropriates and the governor signs.
Well, the origins of these two sections, they used to be the same.
Right.
When the employees were housed in the Department of Public Safety, there's a section 20, chapter 22, section 6, and the commissioner of public safety had the authority under that section to appoint and remove officers, experts, clerks, and other assistants. When the statute, and this happened, this is 1991. Mr. Pino has been working since 1986, I think. So he was an employee of public safety at the time, covered by a collective bargaining agreement with a just cause clause. And when they separated these people out, and the officers who had previously resided in Section 6, along with the experts and other assistants, was moved into Section 10 of 22C when they created the Department of State Police. So Section 10 became certainly where the bulk of the employees in the department reside, officers and other employees, and the governor is going to tell you who you can hire. And at that time, the old Section 6 became Section 9.
Why could we not read this to say that there's a group of people who really have pretty extensive rights? They have civil service rights, they have collective bargaining rights. It's very difficult for the colonel to move people in and out. Very difficult, right? Lots of process. And there's another group of people that he has far more flexibility with. Those are Section 9 employees, and he gets to decide if he wants them or doesn't want them.
Well, I guess.
And then the little kicker here is, can he decide that he doesn't want them for an impermissible reason, not for just cause? He could just decide somebody might be doing a perfectly good job as this man was a DNA examiner. Let's just say the technology has moved and we're now into something completely different, and it's just a drag on the department, and we have limited funds. We don't tax the Commonwealth residents more and more and more. And this gives the colonel the capacity to remove people without all of the panoply of rights and protections of the Section 10 people. He cannot do it, I would submit, for an impermissible reason, right? You can't do it on the basis of race, gender, national origin, disability, and possibly union activity. And then the question is, so is the arbitrator, well, first of all, if it goes to arbitration, who decides that question? Is it a court or an arbitrator? And if it is the arbitrator, why is the arbitrator not confined to looking only at whether the basis of the removal was an impermissible basis? In other words, not was there just cause, but was the basis. You with me?
Yes, the reason, I would suggest the reason is because that's what the agreement says. That, I think, is the reason. And I think the problem, with all due respect.
Which agreement?
The collective bargaining.
Okay. The CBA.
It's what the statute says. When you have a motion to stay come before you, What the statute says is, look at the agreement. Is there an agreement to arbitrate? If there is, you don't stay it. You order it to go forward.
Yeah. But if we don't agree with you on the question of how should the arbitrator look at this question,
Yes.
when an arbitrator considers a case of termination for just cause against a Section 10 employee, the arbitrator, I take it, just decides whether or not there is just cause to terminate this person. It's a de novo hearing, right?
Correct.
Here, if we don't agree with you, and if we say, no, the colonel has the right to terminate somebody's employment for any reason, and if we conclude that the arbitrator's role here is only to look to see if there was an impermissible reason, what if the arbitrator determines there was both? There was an impermissible reason, and there appears to be a basis for terminating this person because of incompetence.
Both?
Yeah.
That would be an interesting case. I suppose it could happen, but typically when that happens, and I had one not long ago. Well,
this is the straw that broke the camel's back. You know, we always wanted to get rid of this guy for his union activity, but now we've got him on incompetence,
He's
and it was
given us cause.
yeah.
Well, then I don't think you get reinstated in that situation, and that's usually what happens. If there's cause to fire you, then there's cause to fire you, and you don't get reinstated. Even if your motive is impermissible, and that's typically how these cases come out. If you can prove that the reason you were fired was an impermissible reason, then the stated reason, the cause, the job-related reason, generally isn't the reason.
Well, again, you're assuming all of this can be in arbitration if the colonel has the authority of Justice Spina's authority, namely to terminate for any reason or no reason at all, then
arbitrary and capricious reasons, Your Honor.
Yeah.
That's what he's claiming.
Then if it's for if he's done it for an impermissible reason, the argument might be that you've got to be in superior court, not in an arbitration. Yeah, the Labor Relations.
The Labor Relations Commission, Your Honor.
Has another name, I know.
Well, they will defer to arbitration if the thing is covered by an agreement. I mean, this is not kind of forum shopping, and we have agreed that these cases go to arbitration. That's what our agreement is.
Yeah, but
all of these questions about what might happen and what could the arbitrator do and what's those ought to be done on review. Once they've agreed to go to arbitration, we shouldn't be running into court saying, oh, he might order reinstatement. Even if he doesn't, Your Honor, even if he doesn't order reinstatement, the arbitrator doesn't. The right to go to arbitration is a substantive right for public employees. For unionized employees, it's a right. I understand when you talk about individuals and so forth, we're talking about waivers of rights. I've waived my right to go to court or MCAD. This is a right that is fairly sacred in the United States since 1960. I mean, we have contributed to the world a system of judicial dispute resolution, which is a model. And we shouldn't be saying, oh, you can't do this because something might happen. And that's what happened here, and that's why it's improper.
Thank you, Mr.
Thank
Kelly.
you.
Ms. Goldman?
Good morning, Your Honors. Julie Goldman, Assistant Attorney General, appearing on behalf of the Massachusetts Department of State Police. The Superior Court here properly stayed the pending arbitration under Chapter 150C, Section 2B.
Ms. Goldman?
Yes.
Given that you have a contract here that has a just cause within it, if it doesn't cover this case, I mean, and that's your argument, obviously, that it doesn't because of Section 9.
Correct.
What does it cover?
The collective bargaining agreement here, as it applies to civilian employees, anything that comes within Section 9, which is the authority of the colonel to appoint, transfer, and remove, cannot be covered by.
But I take it there's thousands of employees in other agencies and other positions covered by this as well.
Correct, Your Honor. Not every,
It's not just with the state police?
No.
it's not just for the state police. This collective bargaining agreement was entered into on behalf of the Commonwealth, acting through the Human Resources Department and the union Moses here. The colonel is not a party to the collective bargaining agreement.
So whatever agency you're in,
You'd
you're-
have to
if
look
you're
to the
Moses-
statutory authority of the head of that agency.
I see what you're saying.
If
Okay.
there's similar appoint, transfer, and remove statutory authority, then there would be a material conflict here.
So let's assume for a moment that you are right, that this is the hiring and firing of these Section 9 employees is sort of a non-delegable function. Still, what remains is firing on improper grounds, impermissible grounds, firing because of the sex or race of someone, firing them because they have engaged in union activities. How do you say that is properly dealt with? Because surely it can be dealt with in some fashion.
The grievance here alleged violation of the just cause provision of the collective bargaining agreement. If you look at the initial...
And retribution for union activity.
I would, it's our position that union discrimination allegation was waived. It was
Well,
not...
let's assume
Let's
it's not
assume it
waived.
wasn't.
Okay, if it was not waived, and it was developed, then there are other forums, not arbitration, that can deal with such a claim. Specifically, Chapter 150E, Section 10 and 11, with regards to the powers of the Labor Relations Commission.
So what would happen? So I am a Section 9 employee. I've been fired, I believe, because of union activities. You say, well, you don't have a right to arbitrate whether there was just cause. Go where and do what?
You can file a claim with the Labor Relations Commission.
Which will then do what?
With the Labor Relations Commission can hold a hearing and can determine if I think there are specific
That's
powers.
Southern Worcester was that, right?
Southern Worcester involved the
Exact-
Labor
yep.
Relations Commission.
But why do you have to go there?
Why
Why
do
not
you
make it?
have
Why
to
not
go
go to
there?
arbitration?
It's that it cannot be delegated to an arbitrator.
What can't be delegated?
The conditions surrounding Mr. Pino's removal.
Well, if
by
it's
the colonel.
if it's an illegal cause, and we said in the Southern Worcester case that it doesn't we said that the non-delegability doctrine did not apply because 150 Section 10 was a limitation on the school committee's power to refuse to renew the employment of a non-tenured teacher.
For the Labor Relations Commission in that case.
Right, you're dealing with two competing statutory authorities. The statutory authority of the colonel under Section 9 to appoint, transfer, and remove, and the statutory authority of the Labor Relations Commission to hear claims regarding dismissal over union activity. What we're talking about here...
Are you saying that claims before the Labor Relations Commission can never be made the subject of arbitration?
Not never, but in this case, the colonel cannot delegate to an arbitrator to hear the reasons concerning one's appointment, transfer, or removal.
So the Labor Relations Commission could essentially send this to arbitration under its powers.
If there was a specific provision in the collective bargaining agreement that warranted arbitration. In this
So
case,
they can't. So the Labor Relations Commission can't send it to arbitration unless there's a collective bargaining agreement that says they can.
It's my understanding that the Labor Relations Commission sometimes defers to the decision of an arbitrator if there's a pending arbitration regarding the similar facts at issue. Here, there is no viable pending arbitration.
Okay.
But could the Labor Relations Commission, in such a fact pattern, forget the waiver, could it grant relief to somebody in Mr. Pino's position who says, and let's say can prove, that the colonel was motivated by my union activity, and that's not, and could he go to the Labor Relations Commission and get relief?
Yes, Your Honor.
And what would the relief be?
If it is proved that the employee would not have been discharged but for his protected activity.
The authority of the Labor Relations Commission specifically speaks to the power of reinstatement. And I believe that was addressed also by this court in the Southern Worcester case.
Now, what if the colonel were to fire a chemist because she was a woman? I take it that's also non-delegable in your view.
Correct, Your Honor.
Where would that chemist have to go?
I don't think it would fall under the labor
MCAD?
relations- MCAD. It could be a constitutional claim brought directly in the Superior Court.
I take it that let's assume that it's MCAD. Let's assume. I take it that if the question was, we granted MCAD's application to set out the legal standard and burden of proof, we would come to the same conclusion, namely that if it proved that the employee would not have been discharged, except for the fact that she was a woman and that she bears the ultimate burden of persuading MCAD that the discharge was unlawful, right? You would do a parallel, I assume.
Assuming that MCAD's statutory authority mirrors that of the Labor Relations Commission, I haven't looked at that specifically.
Well, I haven't looked at it either, but based on what I do know about it, this comes pretty close. I mean,
Yes.
that's essentially what happens at an MCAD proceeding, because an MCAD proceeding is, you're an employee at will, right? Which is, in essence, how you are characterizing the colonel's non-delegable authority here. If he
Correct.
decides he wants to remove you, you get removed. But if he does it because you're a woman or because you've engaged in union activities, you say, the employee says, then you have a forum where you contest that proposition, correct?
Correct, Your Honor.
Now, if you're right, must we overrule Blue Hills versus Flight, where we did permit an arbitrator to resolve an issue of gender discrimination?
In the Blue Hills case wasn't dealing with the statutory authority at issue here. The Blue Hills case spoke specifically about a school committee's non-delegable authority over educational policy in a very general sense. The court wasn't focused on looking at a specific statute there and the statutory authority given to the school committee. That collective bargaining agreement specifically detailed that appointments would be made without regard to sex.
Well, this one does too. This one says you can't discriminate on the basis of union activity. So
It
that
doesn't link it
distinguish.
to appointments, transfers, and removals. It's more general non-discrimination language.
Well, that's true with the sexual orientation, too. The Section 6.1 of the contract says the employer and Moses agree not to discriminate in any way against employees covered by this agreement on account of race, religion, ta-da-ta-da. And Section 6.6 says there shall be no discrimination by the employer, it's even more specific, or its agent, against any employee because of his or her or membership in Moses. I'm looking at page 22 and 23 of the record appendix.
Yes, Your Honor.
It's just it's even more specific than the MCAD, the Chapter 151B types of discrimination.
She's talking about the actual contract in the Blue Hills case, talked about no appointments.
Talked about appointments specifically. This I'm trying to differentiate in terms of the collective bargaining agreement here, that it's just general non-discrimination language. Doesn't come up in the context of appointments, transfers, removals. Here, when we were also talking about the authority of the Labor Relations Commission, that authority is specific with regards to union discrimination and as it relates to tenure. So there could be a claim of union discrimination related to some other factual
Promotion.
scenario not involving the colonel's decision to remove
Promotion?
Mr. Pino.
Promotion?
Promotion.
I don't know whether transfer encompasses promotion. Ms. Goldman, Justice Gans, if you're on the same. Mr. Kelly makes what sounds like a pretty plausible argument that for unionized employees, and Mr. Pino was a member of the union, correct?
Correct.
The right to arbitration is a pretty fundamental right. And there are lots and lots of appointment and removal passages, I mean, at least according to the AFL-CIO's amicus brief. And as far as I know, we've got Southern Worcester, and that's 25 years ago, more than 25 years ago, and we've got Flight, which is sort of not quite on point. I mean, wouldn't this have been absolutely slam dunk settled with lots of precedents? I mean, aren't these employees, unionized employees, going to arbitration every single day? And you just have colonels or their functional equivalents out there who are not saying they can't do this? What's going on here?
Your Honor, my reading of the cases is that a lot of the school committee cases, the school committee is entering into the collective bargaining agreement.
Fair point.
In here, we just don't have that issue where the colonel did not enter into this collective bargaining agreement.
Well, isn't he bound by it with respect to Section 10 employees?
Section 10 does reference...
He didn't sign that contract, did he? Are you
I
saying
don't-
that the colonel doesn't have to submit to a just cause hearing because a uniformed state police officer was fired?
I don't know who enters into that contract.
But are you saying that the colonel is not bound by that contract?
Section 10 does not have the same appoint, transfer, and remove statutory authority as Section 9.
So, but are you saying that the colonel is not bound by any collective bargaining agreement that covers uniformed state police officers if he did not sign the contract?
No, Your Honor.
Okay.
But what I'm saying is that if there is a material conflict between the statutory authority that the legislature has granted the colonel and the terms of the collective bargaining agreement, the statutory authority must prevail, and arbitration should not proceed, regardless of what the collective bargaining agreement says in that instance.
How many do we know how many people? Does the record tell us how many people? For how many people the colonel has exercised this power?
No, Your Honor. I'm not familiar with other instances of this occurring. And again, it's only exercised in this case because the statutory authority in Section 9 concerning the colonel's authority to remove an employee, if the claim here didn't concern Mr. Pino's appointment, transfer, removal, we wouldn't be here making this argument.
If we agree with you, have we de facto turned unionized employees who fall under Section 9 into at-will employees?
They will not be afforded the just cause protections in the collective bargaining agreement.
But other protections, yes.
But other protections, yes. And statute.
Such as what?
I believe the collective bargaining agreement details other subjects such as compensation, shifts, scheduling, holidays, things of that sort that don't deal with appointment, transfer, and removal.
I see. Okay.
It can be the proper subject of collective bargaining.
How can Mr. Pino, if he can't do it through the collective bargaining agreement, and let's just say it was something that didn't fit under the Labor Relations Commission, is there some way that he could challenge the colonel's determination of just cause in this case? Or you're saying the colonel used that language, but he didn't need to?
Exactly, Your Honor. I would say that while the colonel used that language, he didn't need to.
Well, you suggest in your brief that he can request, or maybe he did request, a hearing before the colonel on his dismissal?
There is a statutory provision, Chapter 22C, Section 43, that allows anyone aggrieved by a decision of the colonel to request a hearing before him. The dismissal letter in this case references hearing predetermination. There's not much in the record that details what that hearing consisted of.
So we don't know whether such a hearing took place or was requested in this case?
Correct, Your Honor.
You might be able to bring a certiorari action, maybe, to challenge if you went through that process.
Right, or you could probably bring an action pursuant to Chapter 38, Section 14, after the completion of.
I don't think the state police is covered by 3814. Maybe it is.
Certiorari, then.
Ms. Goldman, I know it's not this case. the transfer and removal, I understand. Appointment, I take it that you would suggest that union bumping rights, for example, would not be in play if it's appointment. He just appoints whom he would like to appoint.
I can't speak specifically to
I know
union
that.
bumping.
Or, I mean, to some other right that, it doesn't have to be bumping, but some other right that might arise under the collective bargaining agreement, you would say that if it curtails the colonel's authority to appoint, then the statute trumps whatever the collective bargaining agreement
If there is
does.
a material conflict between the two, yes, Your Honor.
And is there some place where we have the statute defines or somebody defines experts, clerks, and other assistants? Does that just mean non-police officers?
Yes, Your Honor. In the definition section of the statute,
Okay.
it defines what uniformed officers
But this
are.
is, and these are all the other
and
non-uniformed.
Those fall into anyone who's not a uniformed officer.
Thank you, Ms. Goldman.
Thank you, Your Honors.